Hello. So, idiomatic phrases are phrases where if you were to try to interpret them directly, exactly word for word, in a lot of cases they would not make sense. So, it's good to practice them and think about them so that you have a good rendition on the tip of your tongue. So let's imagine you're in a hearing, a pretrial type hearing. One phrase you could hear from one side or the other would be something along the lines of this: I'm afraid the state is barking up the wrong tree. Or I'm afraid the defense is barking up the wrong tree. Or those police officers were barking up the wrong tree with their investigation. My client is innocent. That sort of thing. What's barking up the wrong tree? What's it mean?
Looking at the wrong person?
You're on the right track, especially in those contexts that I just said, because we would think it's referring directly to that person.
The case.
Making a mistake?
Making a mistake, yes. Like following a lead or an idea that's incorrect. And it comes from, I think the image that it creates in your mind is a dog who's chasing some kind of varmint, and the varmint outsmarts him and runs up the oak tree, and the dog gets confused and ends up barking up the maple tree. And, that situation is what's led to this idiom. So it's kind of just like saying making a mistake. I'm afraid that the state is making a mistake. I'm afraid the defense is in error.
Can I ask a question?
Yes.
So what I actually have a question about is actually the first part, I'm afraid, because I feel like the person isn't actually afraid. I feel like maybe?
Yes. Who's speaking? I'm sorry. I'm having trouble finding it.
Ana,
perdón. I'm sorry. In Spanish, we can use that same set of words and have it make sense. We can use the word for to fear and combine it with other things, but it's not necessarily literally that somebody is feeling fear. It's almost like saying unfortunately or sadly, or in my view, the unfortunate fact is, that kind of thing. So to express that, if actually literally saying I'm afraid in Czech doesn't make sense, then substitute it with one of those phrases like unfortunately or sadly. And unfortunately, or I'm afraid my dogs are freaking out. There must be somebody at the door, so I apologize.
All right, well, thank you.
You're welcome. Mary Ellen made it. Good. Okay, so barking up the wrong tree. Unfortunately, this person is making a mistake or committing an error. This is a good point for me to show you again those websites that I recommended before. I did post on Canvas under the recorded sessions. I uploaded the PowerPoint I was using Monday night, and I included these websites, and I'll post it again. And you should be able to open that presentation and click on the websites and have them take you there. But if you're struggling with how to render I'm afraid in Czech, or how to say barking up the wrong tree in Spanish, or whatever your situation is, these three websites could have some good clues for you. So remember them, keep them bookmarked, and go there often. Especially for the hard to find stuff, Okay, here's another one. I'm sorry, counsel, but you'll just have to bite the bullet and start trial on Monday. You'll just have to bite the bullet and start trial on Monday. What's that?
Accept the decision.
Accept the decision. The decision in this context is almost like accepting this
Bad consequence
or this unpleasant thing.
Oh, okay.
Face something unpleasant. Okay?
Resignarse.
Yes, that would work in Spanish. You can use it in the specific context I made up here, but you can say bite the bullet all the time. Ugh, I'm going to bite the bullet and start my diet on Monday. Ugh, I'm going to bite the bullet and clean up my basement this weekend. Ugh, I'm going to bite the bullet and make that phone call I haven't wanted to make. It just is an expression we use in English anytime that we own up to something and follow through with it, even if it's something we don't want to do. Ooh, I'm going to bite the bullet and call my accountant and pay my taxes. That's that's the context or flavor of the phrase. And again, like we've discussed before, if this were to come up and be something you would need to interpret on the exam, the best thing you can do is come up with something equally idiomatic in your language. However, if nothing idiomatic exists, then you express the meaning, especially if a literal interpretation would just sound ridiculous in your language. If the word for bite and the word for bullet, would really confuse your listener, then you don't want to go that route, and you want to say, you'll have to face it and start trial Monday. That type of thing. Okay, last one. Your Honor, take a look at my client's history. It's no wonder he was not helpful to the police. Once bitten, twice shy. Have you guys heard that one before?
No, never.
No, never. Okay, good. Then
I
it's a good one.
actually have something equivalent in Chinese. It sounds like if you are bitten by a snake once, you are afraid of the rope forever.
Oh, that's
for 10
perfect.
years. For 10 years.
That's kind of exactly what we're saying here, and I wonder if it's sort of a truncation of that proverb or saying that we got it from.
How would you otherwise say it?
Once bitten, twice shy. So it would be hard for me to come up with a phrase that sounds like an idiom, so I would just have to explain it, and I would say, once you have a bad experience, you're reluctant to experience that again. Or he had a bad experience once, so he's not going to put himself through that again. So it obviously requires a lot of words.
Mm-hmm.
Something like learn from your experience or something? Like
Yeah.
Maybe some.
What was that?
But only if you make a mistake, right? You learn from your mistakes.
Right. Yes. And that's another proverb. It's kind of related to this, except for that with once bitten, twice shy, the onus is almost on the experience and not the person. So if I say once bitten, twice shy, it means that I was the victim of something, and so now I'm hesitant to experience that again. Not that I made a mistake and learned necessarily with this particular set of words. So if you were to want to, I think you want to work with the idea of something unpleasant. That was unpleasant. He's not doing it again.
Excuse me, Kelly, can you say to your child, like if you touch the, you touch the iron and you're not going to do it again after he actually touched the iron? Can you say it, something like that in that context?
Well, it would almost be like the way that a native English speaker would use this would be if like, let's say dad is with the kid and the kid touches the iron and gets burned. And then mom says, why won't our kid go near the ironing board? He's like really far away from the ironing board. That's weird. And then the dad would say, once bitten, twice shy.
Okay.
It's more of a description of a person's reaction to a situation than it is a warning.
Okay.
Mm-hmm.
Okay, I got it.
Okay.
Thank you.
Good questions. You're welcome. So what do you do with these? What I would recommend is, since we've talked about them, you've heard a little bit about how they're used. Add them to your collection of flashcards. On one side, put the English. on the other side, put how you might render it. And of course, that could take some investigation if it's not really an idiom you're familiar with in your language. But like in Song's case, once you've been bitten by the snake, you're afraid of the rope for years. That's perfect. So you would put it on the other side and just drill, 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 drill. And then hopefully you'll get the chance to use them someday. Who knows? That's the trouble with idiomatic expressions, is that, you know, you can learn a whole bunch of them and then it turns out that they never even come up. So anyway, I like to have them as a beginning point because it's a good way to spend some of our time while we're waiting to see if other people can join us. All right. So let's dig into what we're here for today. We just did our idiomatic expressions review. And so what I really want to work on is simultaneous. For those of you who have already worked through our arraignment simultaneous for the unit, I'm going to ask you to do it again today in our session. Because practice makes perfect, to have another idiomatic expression, right? Practice makes the master, is how it's expressed in some languages. And I want you, if you've already done the shadowing, to think back to your performance and particular spots that you might not have liked very much. See if you can concentrate on polishing those spots. For your performance today. And in order to do that, we're going to start with a shadowing exercise. How many of you guys have been working on shadowing? Have been adding that into your routine? Yep. How's it going, Martha?
Shadowing is actually, it wasn't as hard for me.
Good. And that's kind of what it's designed to do. We want it to be just a warm-up for your brain. But it's good to get all those circuits working. Anna, have you worked on it too?
Yes, and I find that my brain actually thinks in that way anyway, and I didn't realize it until I had started doing that.
Perfect.
Yeah, simultaneous actually comes very well for me, but the continuous, that one, is it continuous?
Consecutive.
Thank you, consecutive. Mm-hmm. Difficult for me, just trying to remember back of what they said.
Mm-hmm. And that we will also get a workout on that this course.
I must tell you, Kelly, oh my God, you're great with like you can speak so fast and not making a single mistake. Like you go on and on and on and on and on. So with the second exercise, the shadowing exercise, I had to stop a couple of times because I couldn't keep up with you. Okay,
good. And that's another
breaks.
Okay, that's another thing that's important to notice with shadowing is it is easier than simultaneous, but it can be difficult based on speed or even accent and dialect of other people. So, for example, for me in Spanish, people from Cuba have a distinct accent, and it's more difficult for me to interpret and comprehend. So before I go into a session where I know I'll be working with someone from Cuba, I find Cuban newscasts as a podcast and play them and practice them to get my brain warmed up. So that's a tip for you guys. If you know, for example, Judge so-and-so is really, really, really fast, consider finding some type of very fast-paced thing that makes your brain start working really hard to comprehend and be able to talk at the same time.
Where do you find about podcasts? I was actually going to ask you, like I spend a lot of time in the car and I was hoping I could get something to work on while I'm driving.
Sure. Do you have an Android or an iPhone?
iPhone.
iTunes has a podcast app. And to find stuff in Spanish, I will just use search terms in Spanish. News of the day podcast. That type of thing. Mm-hmm. There's another thing, Martha, there's live radio apps. So even though Polish is your stronger language and you would therefore need to shadow in Polish a little bit less, it's still good to get your brain flowing in that language as well. So you can look on iTunes for Polish radio, and you can broadcast news and that sort of thing.
But do they have anything for interpreters, like podcast interpreters?
I don't know for sure, but I'll investigate for you.
Okay,
I'll add that to my list of things to do.
Okay, thank you.
But okay, so with that, let's start out with a shadowing, the more challenging of the two shadowing exercises. So grab your notebooks, your flashcards, whatever you want. I'm going to make sure everybody's on mute except for me. For those of you who have already worked through this exercise, add a layer of difficulty to it. Start writing out numbers while you shadow. Or every 15 seconds or so, switch a word, put a synonym in instead of the word you hear. For those of you who are still, like Martha was saying, this one's a lot faster than the first one. So if you're struggling to keep up, just hang in there and try to just do your best to follow along. So let me get it all set up here. But again, your job is to shadow, just to wake up your brain. Let me make sure we can hear it. There we go.
Illinois compiled statute.
Can you hear that? Let me see if I can see you guys. Were you able to hear it? More or less? Okay.
Yes, yes.
Okay, perfect. Let me make sure the volume of that. Okay, here we go. So make it as challenging or do the best you can to keep up as possible. And we will just shadow. Ready? Oops. Here we go.
Illinois compiled statutes. Code of Criminal Procedure. Instructions. The first time you perform this exercise, record yourself as you shadow it. In other words, repeat it in the same language. Then compare your recording to the script. 2. The next time you perform this exercise, record yourself as you paraphrase it. In other words, repeat it in the same language, and every 15 to 20 seconds, substitute a synonym for one of the words in the original message. Then, compare your recording to the script. Article 109, Preliminary Examination. A. A person arrested with or without a warrant shall be taken without unnecessary delay before the nearest and most accessible judge in that county, except when such county is a participant in a regional jail authority, in which event such person may be taken to the nearest and most accessible judge, irrespective of the county where such judge presides, and a charge shall be filed. Whenever a person arrested either with or without a warrant is required to be taken before a judge, a charge may be filed against such person by way of a two-way closed-circuit television system, except that a hearing to deny bail to the defendant may not be conducted by way of closed circuit. B. The judge shall 1. Inform the defendant of the charge against him and shall provide him with a copy of the charge. 2. Advise the defendant of his right to counsel and, if indigent, shall appoint a public defender or licensed attorney at law of this state to represent him in accordance with the provisions of Section 113-3 of this code. 3. Schedule a preliminary hearing in appropriate cases. 4. Admit the defendant to bail in accordance with the provisions of Article 110 of this code. And 5. Order the confiscation of the person's passport or impose travel restrictions on a defendant arrested for first-degree murder or other violent crime as defined in Section 3 of the Rights of Crime Victims and Witnesses Act, if the judge determines, based on the factors in section 110-5 of this code, that this will reasonably ensure the appearance of the defendant and compliance by the defendant with all conditions of release. C. The court may issue an order of protection in accordance with the provisions of Article 112A of this code. D. At the initial appearance of a defendant in any criminal proceeding, the court must advise the defendant in open court that any foreign national who is arrested or detained has the right to have notice of this arrest or detention given to his or her country's consular representatives, and the right to communicate with those consular representatives if the notice has not already been provided. The court must make a written record of so advising the defendant. E. If consular notification is not provided to a defendant before his or her first appearance in court, the court shall grant any reasonable request for a continuance of the proceedings to allow contact with the defendant's consulate. Any delay caused by the granting of the request by a defendant shall temporarily suspend, for the time of the delay, the period within which a person shall be tried as prescribed by subsections A, B, or E of section 103-5 of this code, and on the day of the expiration of delay, the period shall continue at the point at which it was suspended.
Woo, how'd that go for you?
That was,
I
that
did
last
it
part
better.
was really fast.
I was
Yeah.
better yesterday.
It didn't go too well.
No, no.
It was very fast.
I got lost.
Very fast for me.
Once I started trying to like listen to what they were saying and what they meant by it, then I started stumbling.
Oh,
Mhm.
that's interesting. A lot of times if we're comprehending better, we're shadowing a little bit better, but that might be a good technique to keep in your head. You know, if it starts to get in a hearing where a judge is taking off and I have to work really hard to keep up, we might just have to fall back on being really literal and concentrating only on the words. It's just a matter of practice. So
Kelly, what was the speed of that? Do you know?
I was just trying to figure that out. Let me see here.
You're super fast.
Okay, so it was about 3 minutes worth of audio. 3. Okay, and there are about 485 words. So about 2.6 words per second. So times so about 156 words per minute, more or less, was the pace. So
What
about
is the regular pace?
Sometimes, according to studies that have been done in court, people will be speaking up to 210, sometimes 220 words a minute, especially when judges are reading. And that's why we're always pushing ourselves to get better at going faster. On the test, you are required to interpret that opening statement at 120 words per minute, which is noticeably slower than what we just did. In a moment, we're going to do the simultaneous interpretation. That's much slower, much more manageable, and I believe it's around 110 words per minute. So we're going to have warmed up really fast, and we're going to interpret much slower. And then over time, you'll be able to move up to faster simultaneous interpretation also.
Kelly, can I ask you one question? I'm so sorry. I'm
No
a pain in the neck today.
You're fine.
I wanted to ask you so many times. I do better with my eyes closed. Does it matter at the exam? Like, are they watching you? Like, is the closed eyes allowed? Like,
no, yes, they're allowed. I am the same way. I do much better, especially when I'm tired or when something's particularly difficult. For me, it helps to shut everything out and just concentrate on what I hear. And no, you will not be downgraded for that. There was one type of exam that they used to administer live. I think it was mostly only for Spanish interpreters. And I do believe some were scored on whether or not they were professional in their demeanor. And it's good to train yourself to try to stay professional. But as long as you're not like, flopping and making faces, and then you should be okay, even if your eyes are closed, because it just shows that you're concentrated. But even if you are dramatic and mad and you're flopping around on the day of your exam, they cannot take points off because you're not being graded on your demeanor. You're being graded on how many points you're getting. So, yeah, good question. All right, let me show you some of the words we just heard in that shadowing. Okay. So you got, and there's the script available on Canvas, but a person arrested with or without a warrant, taken unnecessarily delay before the nearest and most accessible judge. This is interesting for you guys to have access to because it's from your state. So these are the rules on how preliminary hearings work in your state. There are words in here that you could predict that you would hear in the arraignment or initial appearance setting. You may hear warrant, which could mean warrant for the arrest. You will hear defendant, you will hear judge, you will hear charge, you will hear counsel. You may hear the word indigent. Preliminary hearing could very well come up. Consular notification, depending on the nature of the charge, that could come up. So my hope for exercises like this is that you guys are able to store them somewhere, download them before I have to take them off of Canvas, so that next time you have an arraignment, oh gosh, it's been a while since I've had an arraignment. I'm going to do this shadowing to wake my brain up and help me remember all the different type of things I may hear. So you can, and I do want you to hold on to these exercises to help you even well after you're certified. So let's move on to simultaneous interpreting, okay? Our brains are awake. We know more or less some of the terms we're going to hear. This one, if I remember correctly, kind of basically there's not an instructions portion, so it'll just start. And it's slower, like I said, maybe 110 words. If this is easy for you, if you've already practiced it and feel like you're pretty well versed, then add a layer of difficulty on this one as well by first trying to increase your lag time. So if you're really good at arraignment simul number 1, then make yourself wait 1 or 2 or 3 more words before you start your interpretation. Try to challenge yourself that way. Or you can do dual tasking for a simul as well, where you start writing out numbers just to continue to develop your ability to concentrate on more than one thing at a time. Okay? And if you haven't done this or you're still not a master of it, you can just concentrate on interpreting. All right? Let's give it a shot. I'm going to turn this back up. Turn this back on. All right, here we go. You guys are interpreting.
Arraignment, misdemeanor court. Pace, slow. Instructions. 1. Record yourself as you interpret this exercise. Then compare your recording to the script. I want to take a few minutes to advise you of your rights and to let you know how we're going to proceed here this afternoon. First of all, you have the right to be represented by an attorney at all stages through a criminal proceeding. If you are unable to hire an attorney at this time, I can appoint one to represent you at no cost if you are able to demonstrate to me you don't have the financial means necessary to hire an attorney at this time. Secondly, you have the right to a trial, depending on the nature of the charges in your individual case. A trial to either a judge or a jury. At that trial, you are entitled to see and hear the state's witnesses. You have the right to bring in witnesses on your own behalf. You have the right to remain silent. You have the presumption of innocence. Throughout that trial, the state is required to prove the charge against you beyond a reasonable doubt. This afternoon, when your case is called, I want you to come up here in front of the microphone. At that time, the prosecutor is going to read the charges. I'm going to advise you of the potential penalties if you're convicted of these charges. At that time, I'm going to ask that you enter into one of three pleas. The first would be a plea of guilty. You should plead guilty here this afternoon if you're admitting the charges that are being brought against you here today. If you plead guilty here today, I'm going to find you guilty and I'm going to sentence you. Second would be a plea of not guilty. You should not plead guilty if you are denying the charges, if you want a trial, or if you'd like an opportunity to speak with an attorney before you decide how you want to proceed with your individual case. If you plead not guilty here today, the matter is going to be set for trial at a later date, and we'll have to discuss the issue of bond in terms of your release. Third will be a plea of no contest. By pleading no contest here this afternoon, you're not admitting the charges that are being brought against you here today, but you're not denying those charges either. If the state can provide me with a factual basis for those charges, I'm going to find you guilty and I'm going to sentence you. If you plead guilty or no contest here today, you give up the rights I just explained to you. However, you retain the right to appeal the conviction and any sentence which I would impose.
All right. How'd that go?
Not bad.
A lot easier when it's slower, huh?
Yes.
Well, the pace made a big difference. I didn't feel like I couldn't breathe.
That's another thing.
But we're supposed to interpret, right, to our own language.
Yes. One moment. Yes, it's easier usually. Well, it just depends. Sometimes when I hear a message in Spanish, which is my weaker language, and have to put it in English, I perform more poorly because I'm struggling to comprehend the message. So if you find yourself really far behind, it could be that you're not comprehending. So you want to get some good time where you comb through all the terminology and start making sure you understand. another tip, when you are in the exam setting, if you're feeling out of breath, you're welcome to stand up. You do not have to remain seated at the exam. You don't want to wander too far because then your headphones might pull out and it would be a big mess. But you can at least be on your feet, which may allow you to breathe a little bit easier when the message is coming so quickly.
Okay.
Right.
It's good to know because I learn better when I walk around.
Yep. So there are some concessions of those types built in to the exam, which is good. Okay. This is really representative of the type of language that you will hear in an arraignment setting. So let's just go through, even though, again, we don't all share the same language, it's still good to kind of talk through as a group what we're hearing and how we're dealing with it. So, Marta, let's start with you. On this screen right now, you see the first 2 paragraphs. Okay. So even though we don't speak Polish, will you read this to us in Polish? Give us an idea of how it sounded when you were interpreting. Ready? Go.
Chcę, żeby przez te najbliższe parę minut powiedzieć Tobie, jakie masz prawa i dać Ci znać, co będziemy robić dzisiaj po południu. Na początku masz prawo do tego, żeby być reprezentowanym przez adwokata przez wszystkie części tego procesu kryminalnego. Jeżeli nie jesteś w stanie zatrudnić adwokata w tym momencie, mogę wyznaczyć Ci adwokata, który będzie Cię reprezentował bezpłatnie. Jeżeli jesteś w stanie pokazać mi, że nie masz finansowych możliwości potrzebnych na to, żeby zatrudnić adwokata w tym momencie.
Thank you so much. That sounded very complete to me. When you did your simultaneous, do you believe you omitted anything in simul that you just included right now in sight? Or did you get it all in?
Luckily, I think I did include everything.
Good. Congratulations. And again,
you know what? Maybe at the first time that I did it like 2 days ago, I think I omitted this afternoon, maybe, or I'm not sure, but maybe one word, but it wasn't too bad.
Good. Excellent. For those of us who have never interpreted really in any other environment but courts, we do get good at getting every little thing in. And that's what's required for us on the test. Sometimes conference interpreters who are better paid and who have to go through more formal training to do what they do, they struggle to become certified in the court setting precisely because we have to be so complete with everything. Now, these little footnotes here are superscript notes 1, 2, 3, 4. Those are only on the screen because I copied this from one that I had drawn a glossary up. So these terms are ones that you really want on the tip of your tongue the next time you go into an arraignment. Rights, attorney, appoint an attorney, and how we handle that in English and how you put it into your language. And financial means necessary. Now, with that particular phrase, you don't have the financial means necessary. This sounds relatively high register in English. So you do not want your interpretation to be, you don't have the cash for an attorney, or you're so broke you can't have an attorney. Of course not, right? But you still have some leeway with the renditions you choose. You could say you don't have the financial means necessary if those words are there. You are lacking the funds necessary. You are not able to find the funding to be able to. There's different things within that phrase that would be acceptable in your different languages. So, good. Thank you so much. Okay. Anna, can we hear this one in Czech? Are you there? There we go. Whoops. Whoops.
Can you hear me?
Yes, I can.
Tak. Za druhé, máte právo jít k soudu.
There we go.
Záleží to na váš individuální případ a sorry, I'm outdoors, so I can't really see it very well.
Oh, okay.
On my screen, I'm sorry.
That's okay. One moment here. If you do end up inside, go ahead and let us know, and I'll find another slide for you to interpret, just to get the practice. This one on the screen says you have the right to a trial. It talks about witnesses and bringing in your own witnesses and having the right to remain silent, presumption of innocence, and then that famous phrase, beyond a reasonable doubt. Now, I know you talked about, Anna, having a legal dictionary in Czech. Have you been able to find equivalent terms?
I'm traveling for outside of state for court, and so I don't have it with me.
Have you been, that's no big deal, but have you been able to find ways to say all those different concepts that come up?
Some of them, yes. I haven't looked at all of them.
Okay. Good.
I'm still trying to figure out what I will use for trial. I usually just say to go to court, but I feel like that's not quite good enough.
Okay. Yes, I think you probably want to go a step further with that. And one resource for you would be maybe to look up on Black's Law Dictionary or a monolingual English dictionary how we say trial. Because the trial is the fact-finding portion of the whole court process. So you want to find a way to make a distinction between that meaning and all the other different things you go to court for. So I don't know, hopefully there is a term already in Czech, and it's just a matter of finding your way to it.
Yes, thank you.
Thank you. All right, Song, I'm going to pick on you. We're ready to hear. Is it Mandarin that you speak, or Cantonese, or something else?
Mandarin.
Okay, we're ready to hear this in Mandarin. One moment. Let me make it a little bigger for you.
今天下午，当你的案子被叫到的时候，我希望你走过来到麦克风前面。在那个时候，检察官将会给你读你的指控。我将会建议你，如果这些指控被定罪的话，有可能的惩罚。在那个时候，我将会让你做以下3个答辩。第一个就是有罪答辩，你应该。如果你承认针对你现在针对你的这些指控的话，那你就应该是答辩有罪。如果你今天这儿答辩有罪的话，我将会裁定你有罪，我将会为你定刑。I'm done.
All right. Thank you so much. Okay.
Thank you.
With what you just did for us, did you read more information into Mandarin when you saw the words? Or was it about the same as when you were simultaneously interpreting?
Kind of the same. Sometimes in Chinese we speak a little bit more, but kind of the same. I feel like Polish or Spanish kind of speak longer than what I do in Mandarin Chinese.
Yes, we do. Well, we got a lot. I don't know what it is, but yeah, sometimes. How do you say, tell me the phrase exactly that you used in Mandarin Chinese for potential penalties. What did that sound like?
可能的惩罚。
Possible.
Okay. And how would you just say penalties?
惩罚。
Okay. Good. I obviously don't know about the choice of words there, but what I was looking for was to make sure there was a distinction between the two, because in English there's a bit of a difference between I'm going to tell you about the penalties and I'm going to tell you about the potential penalties. Potential is like saying possible. So, and this is a good example of, I think it's scoring category unit H, and it's emphasis or precision. So this is the type of word that I would predict you would be scored on if this were your interpretation for the exam, because they want to make sure we are so complete and precise in our interpretation that we get even these little words. Okay? Is there any terminology on here that you're still struggling to figure out how to express, or have you found equivalence for most of this?
I think I got a law degree.
Well, then this is easy.
But this is easy, but the interpretation is not that easy for me. I feel like I don't have enough vocabulary, and when I do the access with you, I feel like so many words that I thought I know the meaning, but when I do interpretation, I can't render the interpretation. I can't render right away.
Okay, so this is an exercise for you, and if any of you guys are identifying with what Song says, I thought I understood this stuff, and then I go to try to put it in my language, and then I'm like, I don't know what exactly how to say that. The benefit of having a written version of the stuff that you're working on is that you can sit down and try to figure out what it means. So in the beginning of your career right now, it'd be a good investment of your time each week to sit with the script and look at each paragraph and see if you can write out the same paragraph, but using different words. Basically, in English, keep it like this, but figure out how you would explain what each of these sentences means. And by making yourself comprehend the message better like that, your chances of coming up with a good interpretation are higher. A lot of times we think it's, I just don't know how to say that. But in many cases, it's more than that. It's like, I'm not completely understanding what I'm hearing. And so to understand better, spend some time on the written versions and rewrite them and make yourself understand them. It'll take a while at first, but you'll get the hang of it. What now?
Sorry, are you saying rewrite in English or rewrite in Chinese?
Rewrite in English.
Okay.
It'll be challenging that way. Don't worry about writing a translation, because if everything we did as interpreters, all we had to do was write a translation, then, we'd be out of a job because everything would already be written down somewhere, right? We have to be really good on our feet and be able to speak it quickly. But if what's breaking down for you is comprehension, work on comprehension. Work on, okay, do I understand this? How would I explain this in different words? And then, look up individual terms that you think are getting in your way. Sure, put those into Mandarin. But challenge yourself to reword it in English to get even better understanding.
Okay, thank you.
Thank you. Yes.
Kelly, I have a quick question. What would you do if you got stuck in the middle? Like, what would you do? Would you still think about, oh my gosh, what you should have said, or you would keep going with whatever is going on at that time?
Great question. Let's imagine, whether it's on the test or in real life, remember our role is to make sure our listener has access to what the judge is saying or what whoever's talking is saying. So our listener does not benefit at all if we freeze when we, So the more experienced you get with exercises like this, the more automatic they'll become, and you can think about other things while you're interpreting a little bit. So sometimes if you say, let's say, potential penalties, in your interpretation you just said penalties and you keep going, and then you realize, oh, he said potential penalties. You can find a way to add that in for your listener. So you're going along at this time. or I'm going to advise you of the penalties if you're convicted of these charges. At that time, I'm going to ask you if you enter one of three, please. Oh, and the penalties are potential penalties. So you can kind of go back and add in the information you omitted if you remember. If you don't, you don't. All we're asked to do is interpret to the best of our ability. So if I'm going along interpreting and I realize I've made a mistake in the moment, yeah, one thing I can try to do is try to correct it quickly. But I only do so in a way that's going to be helpful for my listener. If it's going to confuse things more, then I just forget about it and keep going. If there are times where I've been interpreting for 35 minutes, I'm exhausted, it's really hard, and I usually work with another interpreter if it's something like a trial setting. And there have been times where I've just gotten more and more and more tired, and I end up getting distracted, and there is a portion that's lost because I just end up kind of omitting stuff and then handing the microphone off. So it does happen, but I always try to just always think of my listener and keep making things as complete as possible. But I guess what I'm trying to say is if on the day of the exam you get so far behind that you don't think you'll be able to catch up, it might be better to just drop it and start again. If you're really behind, you're reading right here at that time, and the speaker is clear down here this would be a plea of guilty. You might just want to say at that time, you should plead guilty here this afternoon. That's not ideal. That's not the best thing. But if it's going to allow you to be caught up for the rest of the interpretation, then that is probably the best strategy.
So it's just better to keep going instead of thinking oh my gosh, what was I gonna say? Just keep going with the speech, right? Mm-hmm.
Yes, even if you have to omit on the day of the exam, if you can fix it, like I said, and the penalties were potential penalties, and then keep caught up, that's fine. But it's better to omit and then jump back in than to keep getting further and further and further behind and risk many more scoring units. So
thank you.
You're welcome. Okay. I think I have Rose here, right? Are you still here, Rose?
Yes, I am. Yes, I'm here.
Oh, good. Okay. Will you sight translate this for us?
Okay. Where is it? Okay.
Is it there now? Okay.
Yeah. Okay. Let's see. Segundo, sería una declaración de no culpable. Usted debe declararse no culpable si está negando los cargos, si usted desea un juicio o si usted desea la oportunidad de hablar con un abogado antes de decidir cómo va a proceder en su caso individual. Si usted se declara no culpable aquí hoy, el asunto va a ser citado para juicio en una fecha más tarde y tendremos que hablar acerca de su fianza en términos de su libertad.
Yes, sorry about that. I don't know what happened. All right, excellent. I don't know why that ended up switching on us.
Was that okay?
Yes. I'm sorry. I got a call that came in and then my screen got all messed up. That was weird.
Okay.
All right. No, file, new tab. Sorry about that. Oh, yes. Okay, here we are. Yes, it was well done. Very well done. I like how you said plea of not guilty, denial of charges, trial, speak with an attorney, proceed with your individual case. All of those things were well expressed. Good job.
Okay. Kelly, I have to go now. So
okay.
I'm signing off.
Okay, bye-bye. Go.
Bye.
Run.
Bye.
Okay, for the Spanish speakers that are still on the call, where we see set for trial, Rose said citar. I think a better version, a more accurate rendition would be programar, because that's what they mean. They're trying to schedule it. So that was the difference between cite and schedule for my non-Spanish folks. So set for trial is like saying scheduled for trial.
Kelly, and I
Yes.
heard that she said individual case, caso individual. Could you say caso específico, para su caso específico?
Yes, I think you could. I do.
Would that be okay? Because I don't know, caso individual to me is like, I don't know, just doesn't catch what you were saying.
Yeah, I think I like what you're saying. I say individual case, caso individual, but I see what you're saying with that. And sometimes it does sound stilted. So you could say specific case or your own case, su propio caso.
Okay. Mm-hmm.
Maybe. Oh, I hear somebody, but I can't. I think your connection was garbled. Can you repeat that?
I'm sorry. It's me. There's an echo. Can you hear me?
Yes.
Shoot, I'm sorry.
What was it?
Can you hear me?
Yes.
I'm sorry.
Natalie, I could hear you, Natalie, and then now it's all garbled again. If you
with an echo. With caso particular.
Ooh, I like
still
that.
Can't hear me?
No, I heard that. Caso particular. I like that very much. There you go,
Okay.
Mary Ellen.
That's what I said too.
Okay, perfect.
Sounds great.
Yes. All right. Let's see here. Okay, and let me share my screen again. Good grief, that got goofy. Okay. I didn't get the chance to ask Rose if there were things in that she omitted or that she could render when she was reading that she was behind on when she was interpreting. We'll find out, I guess, at a different time. Okay, last one. Do I have another Spanish interpreter willing to render this for the group?
I'll try. I'll try.
All right. Do it. I'm going to make it bigger. There we go.
Okay. Tercero será una declaración de no lo contenderé. Al declararse no lo contenderé aquí esta tarde, usted está admitiendo los cargos que se le han hecho contra usted aquí hoy. Pero si usted niega esos cargos, ya sea que el fiscal me pueda proporcionar una bases fácticas para esos cargos.
Oh my gosh, I can't hear.
I know.
Voy a encontrarle culpable y lo voy a sentenciar. Si usted se declara culpable o no lo contenderé aquí hoy, usted cede sus derechos que le acabo de explicar. Sin embargo, usted retiene el derecho de apelar la condena o cualquier sentencia que yo impondría.
All right. Very good. Very good.
What did I do? Give me some feedback on the things that should be better. Right.
I caution everybody, and this is for any language where there's a cognate for the word sentence. I want you to research it. For Spanish interpreters, there is some controversy around using the term sentencia to mean sentence, because in English, in a legal context, sentence means castigo, and sentencia in a Spanish legal context means decision in its most pure form. So for purposes of the exam, I would recommend using something like condena or pena instead of sentencia, okay? And for others with European languages specifically, I'd urge you to investigate that and make sure it's not a false cognate lurking there, okay? So work on condena or pena for, well, I guess we have the conviction and a sentence. So I would probably say tiene derecho a apelar la condena y la pena que le impondría. Okay? You can use both there. Pena y condena. What else? How did you say factual basis?
Las bases fácticas.
Perfect. And nolo contendere. So it is acceptable. Nolo contendere is a Latin term in English that we use to mean no contest. So it's taken out of our legal system. And you can leave terms in Latin. Spanish interpreters can. Those interpreters of other languages, investigate and see if there are terms in your legal systems that have been adopted and from Latin and continue to exist in Latin. And if that's the case, you can probably keep them in Latin. I would just say investigate that.
Right? Kelly, I sort of investigated it because I wasn't sure. I know this is a Latin word. I said, you're supposed to leave Latin words as they are. And I was like, or should I put, because I was thinking the person, they're not going to understand. O no me opongo. I say, o no me opongo.
I think, Mary Ellen, I think both are acceptable. But I think you could argue that an English speaker not familiar with the legal setting would also not necessarily understand what no contest is. So I think in this particular situation, it's okay to leave it as nolo contendere. I don't think you're making an error if you do, but you can also say no me opongo and be fine.
Okay.
Okay?
What is the other English word that you could use for no contest? Like if you were supposed to look for a synonym, but not in Latin.
Like what could be used or what is used?
What could be used?
What could be used? Okay. No argument.
No argument.
No argument.
No questionable.
No, no resistance, I guess, is kind of what they're trying to say with it. I mean, nobody does say that. It's always no contest or nolo contendere. But it means I do not resist. It means I do not want to argue over this anymore. So when you say no contest, as you see the judge explain here, you're saying, I'm not saying I'm guilty. I'm saying you probably have enough evidence to convict me whether I'm guilty or not, so let's just get this over with. That's what it means to say no contest.
Could it mean like I'm not disputing this?
Yes. It's allowed. The reason it exists is so that you don't have to say you're guilty. You have a means of acknowledging that there's enough proof to convict you without you having to say you're guilty. Because if, for example, you're convicted of running a stop sign and you say, yes, I'm guilty of running a stop sign and I hit this woman and now she's dead, then her family could use your admission against you in a civil lawsuit. So they've created the no contest option of saying, listen, I know you would be able to prove me guilty. I don't want to say I'm guilty, but I do want to resolve this matter. And that way the family isn't able to come back, or the victim of whatever crime can't come back and say, see, he admitted it. He knows it. I can get $1 million, right? That's why it exists. But it's definitely explained in rights advisories, so it's a good thing to know how to express in your language. Okay? Now what I want to do, we've been through these, you have all of these rights terms at the tip of the front of your brain, tip of your tongue. I have another rights advisory that I'm going to play for you. And it's a little bit different because every judge gives their rendition just a little bit differently. So I don't know exactly how fast this one is either. I think it's faster. I don't think it's crazy fast. Let me get this all turned on. So you guys mute yourselves and begin this rights advisory interpretation.
Okay, folks, listen up. I'm going to go through your rights.
I guess it is faster. Sorry about that. See how you do. I'm going to rewind it for you. And it just starts right away. She says, okay, folks, listen up. I'm going to go through your rights. Here we go.
Okay, folks, listen up. I'm going to go through your rights. It is 10 after 2. The reason I mentioned the time, I need to make sure you were here for the rights advisory. So later on this afternoon, when your case is called up here, I'll make sure you were here at 10 after 2 to hear your rights. You're all presumed to be innocent, and you'll stay that way until the state proves you guilty. You're entitled to a trial, and at that trial, the state will have to prove you guilty by evidence that is beyond a reasonable doubt, or you can't be convicted. You have the right at a trial to see and to hear and to ask questions of anyone who might testify against you. You have the right not to testify yourself. That's your privilege against self-incrimination. You have the right to have subpoenas issued by this court for any witness you want to be present at your trial. All you have to do is tell us who those witnesses are and where they live so that we can properly issue subpoenas for those people. Finally, you have the right to a lawyer, either one hired by yourself if you can afford to do that, or a court-appointed lawyer if you qualify. You can plead one of 3 ways this afternoon: guilty, not guilty, or no contest. First of all, if you plead not guilty, you're telling me that you did not commit the offenses that you've been charged with. If you plead not guilty, the matter will be set for trial in April or May. You will have to come back for trial. Now, don't be discouraged by that. The state will still have to prove you guilty no matter when your trial is. If you plead guilty, you're telling me that you did commit the offenses that you've been charged with. If you plead guilty this afternoon, you will be convicted this afternoon. You will give up all those rights I just described. No lawyer, no trial today, no rights. And you will face the penalties that I will have already told you about. That's what happens if you plead guilty. If you plead no contest, the same thing happens. You'll get convicted, give up all your rights, and face the exact same penalties that you would have faced if you pled guilty. The only difference between pleading guilty and pleading no contest is that when you plead guilty, you're admitting that you did commit the offenses. When you plead no contest, you're telling me that you don't want to admit or deny your guilt. You just want to get it over with today, but the same thing happens whether you plead guilty or no contest. I want to make sure you understand that you also will lose your right to a lawyer if you plead guilty or no contest today and don't have a lawyer with you. That's simply because you are choosing to proceed without a lawyer, which is perfectly okay with me, as long as it's okay with you. But you need to understand that if you plead guilty or no contest without a lawyer, you're going to get convicted. Give up all your rights and get sentenced. All of that's going to happen without a lawyer here to advise you.
Woo! How was that?
That was pretty bad. It was so fast.
It was very fast.
I had to leave out bunches and I would catch up a little bit and then I'd get behind, and a lot of the words were comparable to what, to the one before, but you just didn't have time to get them out the right way.
I agree.
It
was fast.
It was much faster. And then it was also challenging because it's kind of colloquial. Hi, folks, I'm going to read your rights. Okay, sit down.
Like,
Yeah, it's challenging. I will upload that so you guys can practice it.
Perfect.
Don't be afraid to use one of the features in any app you might have to slow it down a little bit to get the hang of it. My guess is that was probably somewhere, again, around 160, maybe 170 words a minute. And we were familiar with the terminology. How would it have gone had we not already been through all this other terminology?
Oh, I don't know about that, Kelly. And then when hi folks, what I came to my mind was hola todos, because I couldn't think of the word folks like right away.
Right. That is funny. And I don't know if you've experienced that. Maybe in your regions, the judges are very buttoned up and reserved, but in my area, especially in traffic court, which is where this comes from, a lot of the judges are very conversational, and their rights advisories sound like that, and they're not used to slowing down for interpreters. So I'll upload this so you can download it and have it to practice too, if ever you have to go and do a rights advisory before a county court judge who goes quickly. One thing to know is, I think in district court, if you ever go in for people who were accused of felonies, if it's sort of a bigger deal case than traffic tickets and red light running and stuff, in district court they do slow down because they're more worried about making sure their listener actually understood, and they understand if I'm talking a mile a minute and there's an interpreter, then there's no chance this guy's going to understand. I better slow it down. So, okay. So that's what I'm going to leave you with. I'll make sure to upload that exercise and you can continue to practice it. Now, we will meet up again Monday night for everybody who's available, 5:30 to 7. And we will start working through what comes next, changes of plea and sentencing. So that's the natural progression of most court cases. Mostly we'll have an arraignment where you hear about your crime, then you go, your lawyers do their magic, you come back, and usually people plead instead of going all the way to trial. So we'll work through some exercises for a plea hearing. I'll make sure we concentrate on consecutive for Monday night. And I'll try to bring some technique exercises to help us too. So that'll be the plan for Monday night. And then Friday of next week, a week from today, we'll have another lunch hour session, and we'll do whichever skills we didn't do Monday night. So we may go back to simul again, or sight. So that's the rough plan for next week. Take some time, if you have it, to start looking a little bit at the change of plea and sentencing exercises. I do like it if you've had a chance to work through them so that you can bring some questions to class with you. So give them a shot if not, just come to class anyway. You'll still learn it.
Okay. Last question. Do you suggest that we should do interpreting or still shadowing? Do you suggest that we should do interpreting of the shadowing exercises, or what should we focus on? Shadowing or simultaneously?
Oh, for Monday night?
Yeah, for the exercises. Yeah, the previous exercises. Today's exercises.
Oh, today's exercises? If you have time to go, if you want to go back and polish anything, do it. But instead, spend some time getting just a little bit of an idea of what's coming up with change of plea and sentencings. So you can do that, shadowing. That's okay to do the technique exercise and leave it at shadowing. You don't have to interpret the shadowing exercises, but do them for change of plea. And then consider doing the consecutive exercise if you have time.
Okay.
Okay? All right.
Okay, thank you, Kelly. I was a little down, but I got energized.
Good, I'm so glad.
I love it. I love this class. Thank you.
You're very welcome. I love being with you guys. Happy weekend. Bye, Margot.
Yeah, you too. Bye.
Bye-bye.